The mics.
You're what?
Live.
We're live.
Everybody tapping on their mics down there.
I did say thank you.
You're on.
Doodar. Who didn't sign that? But
Longest minutes ever. It's time.
Good morning. I'd like to call the zoning board of appeals meeting to order. If I could have roll call, please.
roll call.
Assistant City Attorney Michael Golan is here.
Jim Bonsky.
Kent Anderson.
Tim Martin.
Fernando Ramirez.
Sam George.
Ronnie Carroll.
Pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do you have any public comment at this time? No public comment. Announcements? Okay.
Deputy Clerk.
Okay.
That's enough we can do. Okay, the following boards have, advisory boards or committees have vacancies. The Art Advisory Board, the Audit Committee, Beautification and Tree Scenic Highway Committee, Charter Review Advisory Board, Community Economic Development Advisory Board, Environmental Advisory Board, Historic and Cultural Advisory Board, Joint Management Advisory Board, Parks and Recreation Advisory Board, Planning and Zoning Advisory Board, Public Utility Advisory Board, and Zoning Board of Appeals. The following expiration dates for the following boards. The Planning and Zoning Advisory Board, Citizens Tax Oversight Committee, Charter Review Advisory Board, excuse me, Parks and Recreation Advisory Board, Citizens Tax Oversight Committee, Police Pension Board of Trustees, and Beautification and Tree Scenic Highway Committee.
Thank you. Next on the agenda is a presentation on the quasi-judicial procedures training.
Right. Good morning, everybody. Can everybody hear me okay?
Mm-hmm.
Okay. If you don't know, I'm Mike Golan. I'm your Assistant City Attorney, and today we're going to be talking about the quasi-judicial procedure. I'm sure for most of you this is going to be just a refresher, something you're used to hearing or seeing. They were recently updated through ordinance, so not much has changed, but there are a few little tweaks. So when we'll get into it, and I apologize now for reading it to you, but I don't really have a better way to do it. So, what is a quasi-judicial matter? It's any decision involving the implementation rather than the formation of a city policy. So if the person coming before the board is actually going to be impacted by the decision, then the process is generally quasi-judicial. Why do we do quasi-judicial? It's so that if they don't like the decision of the board or the commission, then they can appeal that decision, and the court looks at the entire process to make sure that they had their rights were intact. So that's why we do a quasi-judicial procedure. So you'll see in your most of you have in your notebooks the flow chart that we put together in my office. It's pretty simple to follow along, and that's kind of what we're going to go over today. As long as you hit every bar on the flow chart, mostly it's just the responsibility of the chair to make sure that you hit every bar on the flow chart. You should make sure that will make sure that everyone's rights are intact. So, if you're required to investigate facts, hold hearings, weigh evidence, draw conclusions, exercise discretion of a judicial, that's judicial in nature. That's kind of what you're doing. So those include site-specific rezoning of land that impacts a limited number of persons, applications for special exceptions, applications for preliminary and final plats, applications for various variances from the ULDC, appeals from administrative determination staff, vacation easements, those sorts of things. Here's the procedure that we were just talking about on your flow chart, and we'll talk about each one individually about what has to take place. So we'll start with your introduction.
Do you want this one?
Does everybody have one of those?
Yes, they do.
Okay. Yeah, just next slide then.
Okay.
So what happens in the first line here? The chair will call and introduce the case, and all the witnesses will be sworn in. That's anyone who's going to speak in the matter or may speak in the matter. So it's all the persons, the attorneys, anyone who's going to give public comment on that item. The clerk will swear those people in. And then when they come up to speak, of course, they'll say, "I'm Mike Golan, I've been sworn." And then they'll present whatever they're going to talk about. The responsibility of the board here is to disclose their ex parte communications if they've had any. So that's, you've disclosed the subject of any communications that you've had regarding this matter, and any independent investigations you've done, if you've done a site visit or something like that, or if you've researched the topic prior to or talked about it with anybody. You disclose the identity of the person, the group with whom those communications took place. Yes, sir.
Are we actually allowed to see the site?
You're not allowed to. So yes, you're allowed to do that. But if you go out and you look at something that you're considering an ex parte type hearing, you'd like to disclose that. I've actually seen the site. I've looked at the area, so I'm familiar with it.
Okay.
Just so that everyone knows that you've actually done that. You're familiar with it. You're not
Okay.
just seeing it for the first time. Because the point is that you are. Everyone knows what you have, what evidence and what information that you have before it gets started. Okay. What's an ex parte? It's any verbal or written expression made to a board member outside the presence of all the interested parties regarding the merits of any matter on which action may be taken by the board. So it's presumed to be prejudicial to the applicant unless disclosed. So if it comes out later that you actually went to go see it prior to, it's assumed that that's prejudicial to the person applying for whatever they're asking for. So better to get it on the record at the time. Yes, ma'am.
I have a question. Okay. If it's not disclosed, and you said it's prejudicial, it could affect the due process. Is that correct?
Right. And that's what the whole ex parte, that's what the whole quasi-judicial process is intended to do, is to protect that due process.
I have a question also.
Yes, sir.
Is there a time period from the time the first decision is made that a person wants to appeal? Is there a time period that they have to make an appeal?
Yes, sir.
And what would that be?
I think it depends on the agenda. Generally, it's, I believe, around 30 days. That's pretty standard. I'm not sure. Some things might be longer, some things might be shorter. But once a final decision is made, generally it's 30 days from the time the final order is issued. So can we make the ex parte disclosure part of the record? The subject of all your discussions, written communications, the existence of anything that you've done, and the experts' opinions that you might have researched or talked to people about, those sorts of things. When do we make that disclosure? Before or during the meeting at which the vote is taken, and the persons who have opinions contrary to those expressed are given then a reasonable opportunity to refute a response. So let's say you went out to the site and you say, I went out to the site, I saw this stuff, and this is what I believe is the case. A person will then have the opportunity to refute that by giving testimony on the record. And that's why you disclose all those things.
Can two people go to the site from the board?
On this board, not together,
Not together.
Not
Or
together.
separate?
separately.
I have a question. If you happen to bump into somebody in a restaurant or something that has something up, is gonna come up in front of us, who do we let know that we bumped into? I would tell them, I'd rather, I'm not gonna talk about it now, but who would we notify that we ran into? Just email Sherry?
You can always tell your liaison, your liaison who's Sherry here. But if it's something that comes, if it's something that I'm not saying that you can't talk to somebody. But if you do have conversation or it does come up in conversation, now amongst yourselves, of course, you meet another board member at a restaurant, don't talk about something that could come up. We've already had that training. You're familiar with that. If it's an applicant or something, someone who you have a conversation with, the proper time to do that is during ex parte communications. Yes, I did have a conversation with the applicant on this. I told him I didn't want to talk about it because it was coming before this board.
Okay.
And that's the time to do that.
It would be brought up during this ex parte.
During the ex parte, correct. You want to make sure that that's on the record in case someone saw you and says, oh, well, I saw them talking about it, so they must have been up to something nefarious. That's when you disclose
At
that.
the time, though, the person doesn't know that you're on that board until they get here.
It's your responsibility to disclose that. Correct. Okay. Next line down is presentation. So it's the chair's responsibility to make sure that the order is, everything's taken in order and that everybody has an opportunity. So of course, the applicant will go first, making their presentation, followed by city staff. Where we get murky sometimes is at the third stage, the aggrieved or adversely affected persons. If it was a day like today and there's nobody in the audience, the reason that we have to make sure that we say, are there any aggrieved or adversely affected persons that want to speak? It's not, it's so that the recorded record is on there. If whatever decision eventually does get appealed, either by the person or by a citizen or by the city itself, the court's going to look to make sure that everybody got an opportunity, even if there's nobody in the room, that it's on the record that it was asked. So that goes for this aggrieved or adversely affected persons, as well as the next slide. Again, rebuttal. Does the applicant have anything that they'd like to say? Does the city staff have anything? Again, aggrieved or adversely affected persons, even if there's nobody there, as long as it's on the record that you asked for it. And that's, of course, to rebut any testimony or evidence, cross-examine, impeachment evidence, anything that either side wants to follow up on that was already spoken about. Now it's up to the chair again. You want to allow all relevant evidence. You want to keep out the irrelevant, the immaterial, anything repetitious. You want to keep the process moving. So if it's irrelevant to the process, it's okay to say, I believe this is irrelevant, or we've already heard enough, but it's repetitious. Let's move on. Guide them along when taking evidence. Hearsay. Hearsay is a term that, of course, me as a lawyer, I'm familiar with it, but you might not be as much. So hearsay is thrown around a lot. It may be accepted to supplement any direct evidence. What is hearsay? So I come and I testify that I heard Sherry say something. Okay, that's hearsay. You don't have Sherry here saying she heard something. I'm saying I heard her say something. That's generally not admissible as evidence unless it's offered to support something you've already heard, right? So Sherry comes and testifies that, yes, I said this, I told this person that, and this is what happened. And then I come up and I say, yeah, I heard Sherry say that to that person who said that. It's hearsay, but it goes to support what you've already heard as testimony from Sherry, so you can accept that as evidence, into evidence. Alone, it would not be sufficient, but in support of something, you can accept that. Any questions on that? Okay. Next is public comment. This is one of those areas where a day like today, you wouldn't even think to ask for it, but it's important to make sure that it's on the record that you asked for public comment. So again, if there is public comment, the person will come up. If they have not already been sworn, the clerk would then swear them in. And then, of course, time limits may be extended by vote if all speakers are given the exact same time. Otherwise, it's the standard amount of time. So even if there's nobody there to give public comment, it's important to make sure that you ask if there's anyone who wants to make public comment on the record, just so that it's recorded on the record. Questions come next. Anybody can ask questions of the presenter or of city staff, any witness, any person that did provide public comment. You can ask their questions at that point. Anything that you need answered, and then finally, closing argument, which is next. Go in the same order, actually reverse order. So you have the aggrieved party was first, city staff, and then applicant. Just to, any questions about that? It's pretty self-explanatory. You have your flow chart. As long as you follow that, you'll be okay. Just make sure that it's on the record as you move through it. Yes.
On the question part, I'm sure you can, like if you ask the aggrieved or whatever, and then you can ask staff, you can go back and forth,
Yes.
like, okay.
You can ask anybody, yes. In the question portion, yes, you can ask anybody. Okay. Action. So at the conclusion of the presentation of evidence and testimony, the public hearing is going to be closed. The presider, the chair, will entertain any motions. Of course, the chair can't make a motion himself or herself. She'll entertain a motion, and the board can deliberate and vote on all motions. Yes.
Counselor, question about the board deliberations and voting on the motion. In the past, we've always allowed the folks that are bringing the appeals forward to be present during the deliberations.
Of course.
Sometimes it might be better for the board to do the deliberations by themselves and then bring the parties in and give them their results. Is there any ruling on that as to which way we can do that?
Yes, that would violate the Sunshine Law, so we don't do that. Everything's done in the public, in the open.
Yep.
Yep, so a nice thought to be able to do that, but illegal. But good question. Next slide, okay, action. So your standard of determination, competent and substantial evidence. Have you received competent and substantial evidence? That's your bar. It's not beyond all reasonable doubt. It's a little bit lower than that. And any vote you take should include your findings of facts and whether or not you approve or deny the application. So based on what my motion would be, based on what we've heard, X, Y, and Z, I move that we approve, I move that we deny the application, and then you, of course, a second, and then you take your vote.
Okay, got a question for you.
One question.
Got a question for you. The client comes in, and he's claiming that the person that gave him all the information down the coding, that they was wrong, and that those people said this, this, and this, and this. Can we require that person from staff to come up here to tell his side of the story?
So hopefully if that's the case, that person staff, of course, will be here, at least somebody from the staff.
I'm talking about somebody in the building department that has the coding
Right.
that said, yeah, they can't do this and this and this.
It would be, if it's something that's going to make or break, I think it would be appropriate to have that person here. Can you require them to be here? No. I don't think you can require them. You can ask that they appear if they're here. If it would help make your determination if they're available. You can't require it. You don't have subpoena power. But staff's usually going to be here to answer any questions that you have or that can come up, or if they need to reply later, if that's an option. Did you have a question?
I did
want to add
have
to
a
that?
question. I did want to add, especially for the findings of fact, usually in your board packets, when we do have an item or a request for variance, you do have emotions an example of whether you approve or deny based on the 5 criteria for granting a variance. And it is critical that you go over the 5 criteria, especially, if you're granting that it meets all of that. And if it doesn't, that you have your facts of why it doesn't meet criteria 1 and 2 to be made as part of the record. Because sometimes we kind of forget, but that way it makes a cleaner record of why, especially for denial, you denied it by, this, finding 1, 2, 3, 4, and 5, and then why to support it, that the code or
Very good
whatever
point.
say that.
Very good point. The more you put on the record, the better. The more the public knows why you did something, or if it's appealed, the court knows why you made your decision, the better. It's a very good point.
Thank you.
And
all I have.
is there another slide? I'm not sure if there's another slide
No,
after this.
that's it. I just have 18.
All right, are there any questions regarding anything else about quasi-judicial procedure? Again, if you don't have a flow chart, Sherry can get that for you, just let her know. She'll provide you with one, or an extra one, or
Yes.
a couple dozen if you need them.
Yep, there should
Okay.
be.
All right, thank you very much.
Thank you.
Thank you.
Okay, moving on to the approval of the minutes for January 11th, 2019 zoning board of appeals. regular
I'll
meeting.
approve the minutes for the January 11th.
Second?
I second.
I'm sorry, who made that motion?
Blonsky?
Thank you. And who seconded it?
I did, Ronnie Carroll.
Who did?
Ronnie.
Okay. I got a show of
Did.
hands, I saw 2 of them. Thank you.
Have a vote for the approval? A vote for the approval?
Aye, yeah.
Aye.
Unanimous.
Moving on to public comment. No public comment. Meeting is adjourned.
Thank you.
Yeah.
Motion to
Round on
adjourn.
that hammer there.
Motion to adjourn?
Second.
Yes.